We have major breaking news out of the United States House of Representatives. And by the way, we can thank, in part, the United States Supreme Court in the Raheem decision for what I'm about to say, which is I'm happy to report that the House Committee on Veterans Affairs has just voted in favor of a major amendment to veterans-related statutes dealing with who can be reported to the NICS system and thereby denied the ability to possess firearms. Let's break down this breaking important news in favor of the Second Amendment, a big win so far for Americans. Let's talk about it. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, so we have a big deal here. I usually don't talk about pending legislation. I think there's other channels that are better situated to talk about such things than this one, but this is particularly important because I need to connect some dots up for you just to show you how lucky we are. I don't want to say lucky because lucky is when skill meets opportunity, but how sort of blessed we are that the U.S. Supreme Court decided Raheem in the way they did it, specifically identifying that you can be temporarily disarmed only if you're found to be a violent danger to somebody else. That Supreme Court precedent has a ripple effect, as you well know, and it had that exact same ripple effect just now with a major win for America's gun rights groups and America's veterans and our Second Amendment, specifically the United States House of Representatives Committee on Veterans Affairs, led by the chairman of that committee, Mike Bost, has just voted out in favor of the Second Amendment, 13-11. 13-11, a Gun Owners of America endorsed, as well as the NRA, the National Association for Gun Rights. Many Second Amendment-related groups were supporting this. The law is entitled the Veterans Second Amendment Protection Act. Now, this was specifically designed to restore the gun rights of almost 250,000. That's right, 250,000 veterans who were wrongfully disarmed by games by the VA, specifically the Veterans Administration. Now, just to step back and tell you what the issue is and why what just happened in this committee is great news and how it ties into Raheem, I want to step back and just remind you what was going on here. Specifically, as you know, under federal statutory gun control law, 18 U.S.C. 922G, that is a list of prohibited people. If you find yourself on that list, on one of those categories, whether you be a felon, involuntarily committed, whatever it is, if you find yourself on one of those categories of prohibited people as defined by 18 U.S.C. 922G, you are prohibited from possessing firearms. You are prohibited from acquiring firearms as a general matter. Now, what was going on here were there are veterans who needed financial assistance, meaning they needed help in filling out their checkbooks, paying bills, understanding their finances, these kinds of money-related issues. And they would have appointed by the Veterans Administration a so-called fiduciary that was specifically designed to help these veterans with their financial affairs. Now, when this occurred, what was going on, and it's been going on for many, many, many years, when the Veterans Administration, the VA, designated that one of these individuals, these veterans, needed a financial fiduciary to be appointed to help them pay their bills and keep their financial house in order and whatnot, write checks and pay bills and so on, things like that. The VA was referring this sort of internal determination by the Veterans Administration to the FBI Department of Justice, who is responsible for maintaining, you got it, the NICS system, which is the background check system that most gun dealers and states use to determine whether or not a gun purchaser falls on that list of prohibited people. So if you find your name in the NICS system as someone that's a prohibited person, as you well know, and you go to buy a firearm and they run a NICS background check after you fill out the Form 4473, it's probably going to come back decline, which means you're not eligible to take possession of that firearm. So what was going on here is the Veterans Administration, without any involvement as a general matter from a court or any kind of court system or anything like that, was making this determination that these individuals were essentially mentally incompetent, analogous to an individual that was involuntarily civilly committed to like a mental institution. But the thing was, this was determination made by a bureaucrat, by an administrator at the VA, and not by a court. So you had 250,000 veterans that needed financial assistance and help in filling out financial forms and the like, which don't we all in many respects. I mean, I don't balance my checkbook that much, right? I mean, everyone, kind of is not perfect when it comes to money and finances, even smart people. Nevertheless, if you needed assistance here and you needed a fiduciary here to help you with your finances, you lost your Second Amendment rights without any kind of a court determination. Well, I'm happy to report that the Second Amendment-related groups, including the Gun Owners of America, the National Association for Gun Rights, California Pistol and Rifle Association, I think, has been on top of this as well, the National Rifle Association, and so on and so on and so on. Basically, the entire Second Amendment community has been pushing to do the right thing here and to provide Second Amendment rights back to veterans who had wrongly lost their right to keep and bear arms because of an administrative decision by a bureaucrat. So there is a proposed bill here, a proposed law by the chairman of the House Committee on Veterans Affairs, Mike Bost, a Republican out of Illinois, who has this to say about what's been going on.
We must ensure that veterans have the same constitutional rights as every other American. Every other American gets their day in court before their Second Amendment rights are taken away. But veterans who fought for the constitutional rights are being treated like second-class citizens. I will not allow the politics of Washington to prevent me from protecting veterans' constitutional rights, which they fought for.
Now, of course, there's pushback from Democrats because, of course, the Democrats don't want anyone to have guns. So rather than wholesale ban guns from all Americans, which is what they would do if they could, they're just trying to disarm Americans one at a time. Now, by banning guns for 250,000 people, they view this as a good start. And a great example of this is Congressman Mark Takano out of California, a Democrat, of course, explaining why this is no big deal. And frankly, it's probably a good thing that these people that need help with their finances have a fiduciary appointed to handle their finances. Why, it may not be a bad idea that they lose their Second Amendment rights. Here's a couple clips from Mr. Representative Tancano right here, right now.
I truly understand that veterans feel singled out by the fiduciary process, but I will remind everyone that VA beneficiaries constitute barely 0.6% or 0.6% of entries into the NICS database, 200,000 out of a database of 33 million. 200,000 out of a database of 33 million, again, 0.6% of entries into the NICS database. The majority's bill completely overlooks the fact that veterans already have the right to seek judicial relief if they object to their name being added to the NICS database. This is a made-up issue. Given this oversight on their part, it is unsurprising that the bill also fails to specify which judicial authority the VA should turn to if it decides to seek an order to report a beneficiary to NICS.
So obviously in Washington, nothing is easy when it comes to our Second Amendment rights, as you can see there. But the better argument, of course, is based on what the Supreme Court said in Raheem. As you may recall, the Raheem case, which many people said was a terrible loss for the Second Amendment community, and I said, no, it's not. It's going to pay big dividends. You wait. Anyone that disagrees with Mark, it's probably you don't need to worry about that, okay? It's a general matter. Not always, but often. So with that said, I said Raheem is going to give rise to great dividends in favor of the Second Amendment rights, and this has proven to be the case today. Because remember, it's not just who wins the case at the Supreme Court, it's how they win or lose the case. So Mr. Zaki Rahimi himself lost the Rahimi case, and he remains in prison as best as I know. I get that. So from his point of view, he lost the case. But if you look at what the Supreme Court said, they specifically said that The reason why Mr. Rahimi loses the case is because he admitted, he was given, basically an opportunity to be heard. He admitted that he did all those violent things. He admitted that he was a danger to his ex-girlfriend. He admitted all this stuff, and it was on the record. And there was a court finding after a hearing that he was indeed dangerous to others, including his ex-girlfriend. There is a court finding. But even there, the Supreme Court says, even though there's a court finding that Mr. Rahimi was a violent danger to himself and to others, he could only be disarmed temporarily. So that rationale finds its way where, folks? Into this law, into this proposed law. Now, of course, this is just the House committee voted it out to the overall House of Representatives, which is great. We don't know if it's going to pass the House, and we certainly don't know what's going to happen on the Senate side, even though they're sponsors of this kind of bill on the Senate side. I think, Senator Kennedy from Louisiana is one of the big supporters of this, John Kennedy down there in Louisiana. So that's a good thing. But again, we'll see how this plays out. But I want you to see how the Supreme Court decision of Rahimi that we talked about last summer, 2024, gets connected up today in May of 2025. And you can see how the spiderweb of law, how these precedents that help the Second Amendment, in the summer 2024 in the Supreme Court, we in the Second Amendment community can now use today in May of 2025. Look at the language in this bill that just was voted favorably out of the committee to the overall House of Representatives. And listen carefully and tell me if it sounds a little bit like what you heard by the Supreme Court in the Rahimi case not that long ago. Check it out. Prohibition on transmittal of certain information to the Department of Justice for use by the National Instant Criminal Background Check System. The Secretary of Veterans Affairs may not transmit to any entity in the Department of Justice for use in the National Instant Criminal Background Check System established under Section 103 of the Brady Handgun Violence Prevention Act. Listen carefully, folks. Personally identifiable information of a beneficiary, that's a veteran, right? A beneficiary of the VA is a veteran. Personally identifiable information of a beneficiary solely on the basis of a determination by the Secretary of the VA to pay benefits to a fiduciary for the use and benefit of the beneficiary under the relevant section of this title. And listen carefully, folks. This sounds in Rahimi. See the dots? Here it goes. Quote, without the order or finding of a judge, magistrate, or other judicial authority of competent jurisdiction that such veteran beneficiary is a danger to themselves or to others. Bingo. See how this works? The same thing we talked about on this channel for the last several years, that the only way I see you are able to constitutionally be disarmed under the Second Amendment is if there is a finding by a court, in my view, after robust due process and clear and convincing evidence, but set that issue aside, don't need to get into that for this video. There has to be a finding by a court that you are a violent danger to yourself or to others. I've been saying that for some time, and the United States Supreme Court in the summer of 2024 in the Rahimi decision specifically said the exact same thing. That violent dangerousness. Then, connecting the dots, folks, that's what we do on this channel. That's why I'm covering this pending legislation, which I usually don't do. I'm doing it to connect the dots for you. The Trump administration was elected. Pam Bondi is made the Attorney General. Harmeet Dillon is the head of civil rights. And what are they all talking about involving the Department of Justice? Thwarting and imprisoning violent, dangerous criminals. You see how this is all coming full circle, folks? The focus of the Trump administration is on arresting, convicting, locking up violent, dangerous people. Not people that are not violent and not dangerous and malum prohibitum, people with victimless malum prohibitum crimes, because they have the wrong stupid hardware in their closet, not stuff like that. That's not the focus. And here you go, in addition to the Rahimi decision by the U.S. Supreme Court, by the focus on criminal justice efforts by the Bondi Trump administration to go after violent, dangerous people. And here you have a bill just voted out of the Veterans Affairs Committee talking specifically that you cannot disarm veterans by a bureaucratic determination that someone needs a fiduciary or has a fiduciary appointed to help them with money and finances and the like. No, you specifically need, and this is what's voted on out of the committee, you specifically need to have an order or finding by a judge, magistrate, or other judicial authority that such a beneficiary, meaning veteran, that such a veteran who's beneficiary of the fiduciary program is a danger to themselves or to others. You see how it all works together? The White House is focused on violent, dangerous things. The Supreme Court is focused on violent, dangerous individuals. And this bill talks about violent, dangerous individuals and findings of that, of such before someone can be viewed as a prohibited person under 18 U.S.C. 922G. And in contrast, these administrative findings by bureaucrats that work for the VA that an individual is not competent to handle their financial affairs without the appointment of fiduciary, that is not sufficient. That is not sufficient. It requires a court finding, just like Raheem, that you are a danger to yourself or to somebody else, just like Raheem. And in that situation, you can be temporarily disarmed, and only that one alone, not any of this other nonsense. Okay? This is very good news. The dots are getting connected, all of which are very favorable to the Second Amendment. Now, let's see if the House of Representatives votes for this legislation and sends it over to the United States Senate. Again, we have excellent Second Amendment groups that do great work on Capitol Hill. It's, obviously above my pay grade beyond what I do. And I generally don't cover this sort of thing because I think a lot of other people do a great job covering legislative affairs. But I wanted you to know what's going on here and connect the dots up because I think it's important for you to see the big picture and how these different precedents that get set either by the administration's positions, by the House and Congress, and by the Supreme Court, how all these things work together to protect and advance your constitutional rights, including your right to keep and bear arms under the Second Amendment. So there you have it, folks. Hope you enjoyed today's episode. Make sure you follow me on X @4boxdiner. Don't forget to subscribe both to YouTube and Rumble. I look forward to talking to you, all of you again, very, very soon here, I hope, here at the Four Boxes Diner.
Orders up. Table 2A.